Hi. Seen everyone. Good morning. Morning. Back to part one. People versus Robert Durst. Mr. Durst is present with Mr. Chesnoff and Mr. DeGuerin. We have Mr. Lewin, Mr. Bailey, and Mr. Miata, Mr. Milius, Mr. Henderson. For the people, I see Mr. Ray is present also. For the defendant, yes.
Is it okay if I pull this chair up right here to handle the exhibits for the moment? There's just a transcript on it.
Just take the lamp again.
Oh, I'm going to move this chair.
Thank you. All right, today's agenda includes the mistrial motion, the consideration of exhibits for admission, and jury instructions. I did receive some communications from the lawyers over the weekend, but I expect that was just to bring aspects of all of this to my attention. I don't know if you need to make any further record.
Your Honor, we've made a decision that the issues regarding the emails will not have to be addressed at this time, and if and when Mr. Durst testifies, if we need to, we'll readdress those issues.
All right.
We do not feel the same way. We need to address the issues from the email that I sent. So,
Well, wait a minute then, Your Honor. If that's
Then that's okay. I'll let you each comment. If he comments, he makes.
Okay, thank you.
so as the court's aware, when Dr. Klein testified,
Oh, and for the record, I'm sorry to interrupt you. Before I forget, I did hold an ex parte conference with defense counsel on defendant's health issues.
Oh, okay.
So, and I've sealed the transcript of
Thank you.
that. But you may proceed, and I'm sorry to interrupt.
no problem, when I think I still owe you a few on that account, Your Honor. I think it's pretty clear when Dr. Klein testified. I understand my cross-examination was limited to 5 minutes. I understand that I think the court very likely did not consider what Dr. Klein had to say to be very credible. That being said, as the court is aware, one of the questions that I asked him was how much money he was going to be receiving. At the time, he gave an hourly rate, and if you recall, when he said just the review of transcripts would have put him at approximately $130,000. He said no, he's only charged $40,000, and that it would be approximately another $10,000. I was very skeptical about that. I didn't believe it. I didn't believe it for a number of reasons. I felt that Dr. Klein's testimony was not just him being an advocate, but some of the things that he talked about with respect to mental state and informed consent are things that not only are completely outside of his area of expertise, but no expert is allowed to comment on a legal issue such as informed consent, etc. In addition, the idea that he was making assessments about Mr. Durst's condition, that he's been paid this amount of money, he knows nothing about what's occurred in the trial, hasn't viewed anything, hasn't read anything, led me to believe that, okay, this is a hired gun coming in here to say whatever he needs to say. However, I was suspicious. So the next morning, I sent an email to Mr. DeGuerin stating that I wanted to have all the billing sheets, everything that he's done. I waited a few hours, and I sent back, if I recall, I'm estimating my timeline right now, and I sent back a second email that said, listen, I want the billing stuff that he submitted immediately, now. And I got it. And let me tell you, when I looked at a billing sheet that he sent the very day that he testified, literally, it appears, Your Honor, that he testified in front of this court and either went to the car or went home and went in the hallway and sent an extra bill, not for $5,000, not for $10,000, but for almost $25,000 more, 2.5 times. I'm also concerned that upon immediately receiving that, Mr. DeGuerin did not immediately forward that to the court and forward it to counsel, because obviously this is information that at the very least impeaches Dr. Klein, and potentially a lot worse than that. So why is this important? This is important because what the defense appears to be doing, their strategy from what I can see, is they have now said, listen, our client is so ill he cannot testify. I have a concern, I don't know if it will come to pass, that what they will do is they will get up here and at the very end, they will not have him testify. And what they will do is they will say, listen, he wanted to testify, it was always against our objection, but we can't call him, Your Honor, because we're not going to sacrifice our client's life and have him testify and potentially die. Now, the reason that that becomes important is Dr. Klein is sitting here saying that Mr. Durst needs to be in a hospital. Something he never acknowledged, and again, I didn't have time to cross him on, Mr. Durst lives in a hospital. He's not a normal inmate who has to schedule a time to go to the doctor. He literally lives, he resides in a hospital with doctors who are seeing him every day. Apparently Dr. Klein didn't find that to be relevant information, didn't share that with the court. However, I'm very confident and would bet $1 billion, $1 billion to 1 to make a buck. I'd put $1 up against $1 billion on my end that you're not going to grant this motion. I'm not worried about the court. The court was able to assess and weigh everything. What I am worried about is the record on appeal. And what I'm asking the court to do is to make certain factual findings. That number one, that Dr. Klein's testimony has been impeached, that the court does not find him credible for some of the reasons that I've said. That becomes important because the Court of Appeal is going to have more of a naked record, and I want to make sure that what ends up happening is right now, the court has reviewed all the medical records from USC. Those records clearly indicate Mr. Durst is getting a level of care that is far better than someone would get at a county hospital who was not an inmate, certainly better than probably every other inmate in that county hospital. And the fact that he's not getting a level of care that Dr. Klein would like with the best specialists in the world, unfortunately he killed 3 people and he's charged with murder. So that's kind of how it works. We're asking the court to make those factual findings, not for the court's really concerned, but because we want to make sure that a court of appeal, if they look at this issue, is going to understand that this is not an accurate assessment. And then number 2, related to that the court make a factual finding that although Mr. Durst, I want to be clear, we have never said that he does not have health issues and that those health issues are serious. Never have we said that. What we have said is that the defense and Mr. Durst, from the start of this trial, before COVID, before anything, have made approximately 20 motions for mistrial for 20 different reasons. So in the end, what you're left with is, what they want is a mistrial, and any way they can get there, they're going to do it. Mr. Durst is further impeached, and the court has it. After COVID, and this was submitted to the court, Mr. Durst was caught on a jail call, and the court has it, talking about how he was not happy with the trial, he was not happy with the jury, and he wanted to use COVID. His exact words were similar to, he intended to use COVID to get himself a new trial. So our position, Your Honor, is that although Mr. Durst has health issues, he is absolutely manipulating these proceedings, that he finds himself right now where the trial has not gone well, and they want a mistrial. So we're hoping the court will make a real solid record. Maybe the court's planning on doing that with the motion anyway, but we're just concerned, not from the court standpoint, but on appeal. Thank you, Your Honor.
Mr. Chesnoff?
Mr. DeGuerin is going to argue. I just want to respond to one thing. I'm glad that Mr. Lewin has confidence in the court after 5 years. I don't even want to respond to him anymore. I wish it had been this kind of nonsense had been stopped 5 years ago, and we wouldn't be listening to it today, Your Honor. His personal ad hominem attacks on people. Dr. Klein, I can tell you, is one of the most altruistic people I've ever spoken to. I don't think Dr. Klein came in here with any purpose other than to express his medical opinion. I'm going to say one last thing. If there was any question about how ill Mr. Durst really is, Mr. Lewin would have had an expert to say he doesn't have the conditions. He has not produced a single scientific other than Lewin on medicine. I'll let Mr. DeGuerin.
Your Honor, I do need to respond just briefly to what Mr. Chesnoff said.
All right, we'll go back. Wait, oh, do you want to do it that way? Okay, respond to Mr. Chesnoff, but you won't respond to Mr. DeGuerin, or can you save it up until Mr. DeGuerin is done?
The reason that we have not submitted, quote, medical information is because the court has the medical information from the horse's mouth. All of the doctors at county who are treating him. So the idea for Mr. Chesnoff to stand up here and act as if the record is uncontroverted, that there's nothing to support the things that I have said or the actions the court has taken, we're not presenting it because, as the court is well aware, both sides stipulated that the court could review all the medical records. The court has been in contact with the lawyer for the county medical people, etc. And there is nobody that we could call that would be any different than the records the court has. And obviously, something that doesn't seem to get noted or related by the defense, if Mr. Durst were not able to come to court for trial, those doctors who see him multiple times a day would not be sending him. So that's just an untrue statement, and they know it.
Before Mr. DeGuerin commences, I have had contact with the lawyer, Ms. Joint, for the hospital, for the jail hospital, but only to facilitate the transfer of records. Everything I am considering is here on the record, with the exception of your offer of proof, Mr. Lewin, about the billing. I don't actually have that on the record, but I'll take it as an offer of proof. So with that, Mr. Guerin?
Mr. Lewin sent me 2 emails regarding requesting the current billing. I got them at the same, or I read them at the same time, and within, I believe, 5 or 10 minutes, I sent Mr. Lewin the 3 bills that we had then received. I had only received 2 bills when Dr. Klein testified. And in fact, he overestimated what he had charged in his testimony. I've reviewed his testimony, although we don't have it in writing. We have it on camera, and so I reviewed it.
I won't fault you for
Yeah.
delay in sending the medical records back to Mr. Lewin. I wasn't thrilled to get emails about this over the weekend, and I'm not requiring that anyone work over the weekend during this trial. Nevertheless, I find myself doing just that, but that's all right. The point is, I do have those records now, and they are consistent with what Mr. Lewin is suggesting. But go ahead, you may argue.
Well, that's Mr. Lewin's interpretation, though. I believe the records fully support what Dr. Klein said. And what I sent to the court was what Dr. Klein had outlined from the records you already have, to save you from having to go through 1,000 pages of records to get to the...
No, I did go through 1,000 pages of records. I
Well,
saw that and everything else. But go
So
ahead.
what I sent you was highlighted the records that you already have, from the records you already had, excerpts, which show, every one of them showed cognitive effect of his conditions, the cognitive effect that they have on him. I mean, the conditions have on his cognitive abilities. Now, as far as the billing is concerned, that's a completely separate issue, and I've reviewed that. And what Dr. Klein said was he estimated what other charges would be, and he underestimated it. So it was an estimate. I'm working with Dr. Klein now in an effort to compromise in his billing, and if we get that, which he's willing to do, then we'll submit that to what he said. But as far as what Mr. Lewin says about the records, they fully support Dr. Klein's review of them and his stated opinions of what they mean, and that is that Mr. Durst is very ill and needs hospitalization. In fact, he was taken to clinic Friday. We don't have those records yet because Miss Joint is on vacation. And I asked her for the records, but I got an automated response referring me to another lawyer in her office. I talked with that lawyer, and she doesn't have the ability to get the records. So we don't have the latest records of Mr. Durst's condition, and the doctors put the catheter back in on Friday.
So when you say the latest records, you're talking about the last week. We have the last 5 years up to the previous week, up to the time of your motion, but not a subsequent examination on Friday where the doctors determined that he ought to have a catheter, a urinary catheter, right?
That's correct.
Okay.
That's what I said.
Just to be clear that we're not operating without records or without a substantial difference from what we had before, only that he had a catheter, it was removed, now it's back. So in that sense, it's reversed or returned to the condition it was previously, and that we know. So there is that condition. It doesn't bear upon his cognition specifically.
Actually,
only in the sense that Dr. Klein suggested it did.
But it's not just Dr. Klein that suggested that it bears on his cognitive ability. It's throughout the records. That's why I sent you the excerpts that Dr. Klein sent to me from the records you have, which highlighted all the statements that the doctors treating him with LA County put in about the cognitive effect and the cognitive deficits. Those are there. But to the contrary of what Mr. Lewin states, Mr. Lewin has not offered any evidence that contradicts what the records say and what Dr. Klein says. Now, on the sole issue of informed consent, that's something that doctors are very familiar with, because it happens in every hospitalization situation, and probably in private medicine also, without being in the hospital, to get an informed consent from the client. Is the client or the patient capable of giving informed consent? And Dr. Klein stated his doubts about that because of the cognitive effect his conditions have. So, bottom line is, we don't have the records from the latest treatment, which apparently found that, again, Mr. Durst was unable to void, and therefore his bladder was filling up with urine. That feeds back to his kidneys and creates a possibility of sepsis and further damage. His condition is declining, and the court doesn't have that information yet. So we'll stand on what Dr. Klein says, and when and if we get a resolution on what the charges are, we'll let the court and Mr. Lewin know. But I have to defend these rabid accusations that Mr. Lewin makes about Dr. Klein. Dr. Klein has gone over and above what ordinarily would be required of a testifying expert. He has not charged for many of the conferences that we've had. He's not charged for some of the review that we've had, but the review is extensive, of thousands and thousands of pages of medical records. And his testimony was accurate. Thank you.
Your Honor, just very briefly, if the court's going to incorporate, because the defense keeps saying that we've offered no evidence, which is incorrect, the evidence we offered is we stipulated with defense counsel that the court could review and could consider the medical records. The court itself said last week, and I'm paraphrasing Mr. Lewin, I assume you're not going to be calling any experts. There's no expert that's available from the county to testify today, and I have all of the records. That's my memory of what the court said.
Yes, I received the records by stipulation of the parties.
So we're asking that that be incorporated, Your Honor. I think the court's doing that already. But it concerns me when they keep making an argument that their medical expert is in essence uncontroverted. It's just factually untrue.
Anything else? In the legal context, we use a different paradigm from what a doctor in a purely medical context would describe as ideal treatment for a chronically ill individual. The controlling case is People versus Avila, 117 Calap 4th, 771. Avila held that a defendant was not incompetent as a result of chronic physical condition. The defense attempts to distinguish Avila, but the distinction is without a difference. In Avila, no documentary or testimonial evidence was produced supporting defendant's statements concerning his physical, mental, or emotional condition. Defendant was seen by a health professional. No evidence was presented on the following day indicating that this professional deemed defendant in urgent need of immediate medical treatment, or that this professional considered defendant unfit to continue trial. Here, we do have the sort of testimonial evidence absent from Avila. Though Mr. Durst may have a report from his privately paid doctor which describes authentic, serious, and chronic maladies, emphasizing the urgency of his condition, and though Avila suggests this type of evidence would be necessary, it does not say that this alone is sufficient. Avila notes the California Supreme Court had rejected a similar claim about inability to testify. That defendant may have been somewhat distracted by pain and other symptoms of physical distress does not establish incompetence or mental absence. They cite Fry, 18 Cal 4th, at 952, that testimony that the defendant could not tolerate stressful situations and may not retain information long enough to properly testify in his own behalf did not prove incompetence. The description of defendant's condition is offered to support a conclusion that he cannot testify, but it does not establish a threshold. The point at which testifying exceeds the medical burden of other trial activities and supposedly becomes lethal, such that he must choose between testimony and death or silence and life. The lack of evidence of a threshold level and only a vaguely progressive continuum is underscored by this. Dr. Klein not only advises that Mr. Durst should not testify, but he should not be on trial, and he should not even be in jail. Dr. Klein has not observed Mr. Durst in the courtroom. Mr. Durst is hardly somnolent. His attention drifts only occasionally during the more tedious parts of the proceedings when anyone could be excused for a lack of focus. Indeed, Mr. Durst is a quite active participant. He dresses for court, he listens, he writes notes, he talks to his lawyers, he waves to the friendly witnesses and acquaintances in the audience. He has endured 11 weeks of trial, but remains mentally present. We've paused the trial for his appointments and one hospital admission. We're in session only 4 days a week and sometimes 3 for his benefit. Though occasionally he has been incontinent, the doctor embellishes by describing a situation he has not even observed, as if Mr. Durst every day were sitting in a pool of urine and feces. That's just false and stating this falsehood reveals the witness's bias. If Mr. Durst is suffering, he does not show it. Dr. Klein's reports are not objective, but works of advocacy. He even invokes the Holocaust as if this prosecution were a war crime. The histrionics are contradicted by the medical records, which in fact support his treating physician's determination that Mr. Durst is fit to come to court. The mistrial motion suggests a due process claim that Mr. Durst is physically unable to testify, but the evidence does not show he is unable. Rather, there's an obvious tactical advantage to Mr. Durst should he choose not to testify. Meanwhile, to the extent that Mr. Durst must endure physical challenges, the court will take measures to mitigate Mr. Durst's discomfort, taking breaks as needed, consistent with the defendant's stamina. While Dr. Klein suggested with a delay Mr. Durst's overall health will improve, he never testified that Mr. Durst would regain the supposed loss of cognition. Thus, there's no basis for delay. Finally, Dr. Klein writes that he will not comment on the legal context of Mr. Durst's situation, quote, regardless of the legal issues of which I will not and should not comment upon, end quote. But this is the most important circumstance. Here, the gravity of the crime dwarfs the significance of Mr. Durst's illness. This is not simply a 10-year-old mail fraud, such as in U.S. versus Duran, 328 Federal Supplement 1261, where the magnitude of the case was incomparable to its impact on the terminally ill defendant. Here it is the opposite. But the defense asked the court to simply declare a mistrial, end the proceedings, and give Mr. Durst an ankle bracelet. This is a capital murder involving evidence of 2 additional murders. The law does not support ending proceedings, suspending proceedings, or releasing the defendant prior to a verdict. Contrary to Dr. Klein's insinuations, there is 0 evidence of mental incompetency. Here is the legal standard for substantial evidence of incompetency. If a psychiatrist who has had sufficient opportunity to examine the accused states under oath with particularity that in his professional opinion the accused is, because of a mental illness, incapable of understanding the purpose or nature of the criminal proceedings being taken against him, or is incapable of assisting in his defense or cooperating with counsel, the substantial evidence test is satisfied. That's People versus Rodriguez, 8 Cal 4th, 1060 at 1110 and 1111. First, the witness is not a psychiatrist or psychologist. He is a kidney specialist and disproportionately paid. Second, Dr. Klein's testimony that Mr. Durst was examined by a psychiatrist in the jail does not raise the inference of mental disorder. In fact, the psychiatrist's report on May 30th, 2021 of no evidence of mental illness despite the odd behavior dispels any such inference. Third, Court's Exhibit 15 shows that the jail nurses examine and record his psychological functioning daily and record his and that his mental health is perfectly sound, including consistently normal affect, behavior, appearance, mood, thought content, judgment, thought process, speech, and orientation. Saying records support Dr. Klein's opinion regarding mental health is a stretch. I do not agree. Fourth, cognitive decline is normal. We see gradual decline among elders, and that is consistent with the medical records. In Mr. Durst's case, that would be decline from a very high baseline. This is not the same, and it is qualitatively different from a mental illness or a thought disorder that might suggest incompetency. And in fact, if there were such a disorder, even that is not determinative. Often it is present among legally competent persons. Fifth, it is important to consider Dr. Klein's nomenclature. Dr. Klein uses the term diminished capacity, which is not a useful term in modern California criminal law. It's a term used to describe a defense that was abolished in California about 30 years ago and does not have any legal meaning with regard to competency. Diminished or impaired cognitive ability, short of incompetence, which might affect decisions or testimony, does not support a mistrial or even a continuance. See the Fry case, which is cited in Avila. The doctor's imprecision reduces his credibility. He's better on the kidney issues. Thus, Dr. Klein's opinion that his capacity is impaired and that he can't make an informed decision about testifying is an opinion beyond the scope of this witness's expertise. It lacks a factual foundation. It is contrary to the evidence. It is the product of bias, and I reject it. A mistrial motion should be granted only when a party's chances of receiving a fair trial have been irreparably damaged. People versus Ayala, 23 Cal 4th 225 at 283. Here, that is not so. Motion denied. Next, exhibits.
Your Honor, can I bring up, before we do exhibits, can I bring up something with the defense expert for tomorrow?
Defense expert tomorrow? Yes.
Yes,
Yes.
Dr. Loftus.
Yes?
So the defense sent me what is in essence an offer of proof. And here is the issue. What they sent me, hold on one moment, Your Honor, I want to open it up here. So what they said is they said that she's going to testify to the following. She's going to testify regarding her studies of human memory, how memory can be changed by things that people are told. She's also going to testify to ideas, suggestions, and other post-event information can modify people's memories, and that people can get distorted memories of things that happen to them, or even develop entirely false memories. She's going to say that memories can be contaminated with misinformation, leading questions, media reports, and other witnesses' false recollections. She's going to say false memories can be expressed with a great deal of emotion. She says that as time passes and a memory is getting weaker and weaker, it becomes more vulnerable to post-event information.
Slow down a little bit and maybe
Oh, sure.
speak up, please. I'm
Sure.
having a hard time.
She then says, as time passes and memory is getting weaker and weaker, it becomes more vulnerable to post-event information. It says Dr. Loftus has not made any reports in connection with this case. It says she's been provided with all good things and reviewed the Jinx. And here's where we get to the real problematic areas. She's also been provided with a copy of the people's opposition to the 1390 motion and exhibits, that's the forfeiture by wrongdoing. As we
That's the
approve
what?
the forfeiture, the copy of the people's opposition to the 1390 motion and exhibits, that's the forfeiture by wrongdoing. And then it says, as we have previously indicated to you, we have provided her with statements you have disclosed and or transcripts for witnesses including, and then it goes through a list of 41 witnesses. Now, here's the issue. As the court's aware, under the law, she is not allowed to comment about her opinion of different witnesses. She can't do it. I don't care. I'm more than happy if that's where she wants to go. But I intend to cross-examine her. I just want to make sure in advance, because obviously, as the court has said many times, the court's absolutely right. Just because one side allows evidence that would be inadmissible doesn't mean the other side gets to do it as well. So here's
It's a Sanchez issue, and that is that inadmissible evidence, unless it's admitted, it can't be introduced through that witness. I expect that that's the purpose. It makes a lot of sense to me. I mean, it seems to describe an overall critique of the people's case, which describes events over 40 years where there have been media reports. I understand there's good cross-examination also, but that's all fine.
So all that I'm saying, Your Honor, is that normally I would be objecting to her commenting on any particular witness, but they've said she's reviewed it. bring it on, and I intend to cross-examine her on those specific
I think there
witnesses.
can be hypotheticals based on the scenario of a particular witness. She's not to comment on the witnesses in this case. It's not her place to do that, but she describes how memory works, how memory factors that can affect deterioration in memory. There's the idea of false memories, of which she's a leading proponent of that idea. And then, but as far as any particular witness, she would describe hypothetically that scenario and how would these psychological theories or principles apply, and that's fine.
What I'm offering, Your Honor, what I'm asking is, as long as the court will let me cross-examine her on it, I have no objection and would welcome her commenting on, she's gone through these transcripts, I want to know what she's looked at. I welcome her to comment on particular witnesses. I just want to make sure I can cross-examine her on it. If the court is saying,
No, well,
I'm not gonna
I'm
allow
not
it.
going to let the defense do that. So I think it's not a good proposition for them, really. So I'm not going to let them do it. I think the hypothetical works better.
all right, if they are allowed to do that, I'm just saying that I intend to cross her on that same information. That's all.
Okay? Well, now, we're talking about exhibits. Now, as I was going to say, we've already heard objections to exhibits as they were presented. So are the people moving to introduce all of their exhibits into evidence? Are there any exceptions?
Yes.
Will you note the exceptions, please?
Just the exceptions for me to know?
Yes.
3A, 4A.
Do you have a list? I mean, is this long?
Oh, there's like 1,000 altogether, so.
There are 1,000.
Exhibit, I mean, I didn't count them, but there's a lot of exhibits.
How many omissions do you have?
If the court would give us like a,
I'll give you time to prepare a list.
yeah, that's what we're doing right now, we're halfway through.
Sorry, I didn't mean to rush you. I didn't realize you needed more time for that.
No, it's our fault, we should have this ready, I apologize.
But let's go to instructions. Okay, shift gears, jury instructions.
And before we do that, Your Honor,
Yes?
on the exhibits, we have a spreadsheet which lists each exhibit. Would you like us just to mark on that spreadsheet the ones that are we're not admitting?
Yes.
And then we'll leave a blank space for the other?
Yes.
Okay, thank you.
Before we go through all of the instructions, would it be possible, Mr. Balian and Mr. Miata are handling that area, but I received 2 instructions requested from the defense to
Let's do the courts. This is how I want to do it.
Okay,
I will go through the instructions that I proposed. Almost all of them are standard instructions from our jury instruction book known as Cal-Crim. And California Criminal, colloquially known as Cal-Crim, but it's also Judicial Council of California Criminal Jury Instructions. I've selected the standard instructions that I believe apply, and then I have modified them for gender, number of witnesses, etc. Most of them should be non-controversial, but some of them will be. I recognize that. So I will move through the instructions one at a time. I'll listen for whether there is an objection. If there is no objection, then I will give that instruction. Then I will look at proposed modifications. I've received proposed modifications from the people. And then I'll look at any special instructions. The defense has 2 special instructions so far. And I realize we're early, right? I have done this earlier than this, but this is not the end. In other words, when the evidence is closed, we will know, first of all, whether any additional special instructions are appropriate, and also we will know whether some of these instructions apply. For example, the defendant's right not to testify, and the instruction emphasizing that the jury is to draw no negative inference from it and not even to comment about it or discuss it. I will give that unless the defendant is testifying, and we'll know that at the end, and I'll delete it. I'll delete that if he doesn't testify. So you understand my method. Now I realize.
Can I make a request of the court? Because
Yes.
I only have 5 comments really about the ones that you gave to me, and if I can do those, I can do those very quickly. I think we can get through that.
Well, you'll be surprised how quickly we can get through this my way. But okay,
Well,
tell me which ones. No, each number.
Because I'm not feeling well, so
Which-
I'd like to get those on the record in case I have to.
All right, Mr. Ray, which ones are they?
Page 13, you have the evidence of uncharged offenses.
I'm sorry, the pagination is not consistent, so let me. Yes, give me you have a number referencing the calc room. So
I apologize,
did you
Your Honor.
you didn't do that? You went by page?
Yeah, I did. It's the uncharged offense. You can consider.
All right, tell me what page is on yours?
13.
It's the domestic violence evidence.
Uncharged offenses. All right, yes, I'm there. And now which one?
It's the domestic violence can be considered whether he killed Kathy. I think that is not appropriate. I think that the court should say that the domestic violence evidence can relate to establishing can be considered to establish their relationship, which the jury then can consider with regard to other relevant issues. But I don't think it's right to say you can consider that as to whether he murdered her. I think what it establishes is their relationship, and then the relationship can then be considered if they deem that to be relevant.
Our position, Your Honor, that instruction is completely appropriate and necessary, and that instruction and variables of it are given every day in any domestic violence prosecution. And in essence, in proving up Kathy Durst's killing, we are treating it as a domestic violence homicide. It's appropriate and necessary.
Right. It's more than just establishing their relationship or its nature. It's used from which an inference can be drawn that there was additional violence committed.
All right. The next objection that I have has to do with modus operandi, where it's indicated they may consider.
Wait, we're on 375?
Well, unfortunately, again, I didn't put it.
The same instruction?
I think I can help Mr. Ray with this because he might have.
Where you may consider the evidence. Please.
No, I'm trying to show you this so you can tell the judge what page it's on.
Page 14.
Well,
There is evidence that he did not murder. In other words, what I'm talking about there is the destruction of the body, the hiding of the body.
Okay, just a moment. If you decide defendant committed dismemberment of Morris Black?
Correct. That's it.
Okay, what do you suggest?
What I'm saying is that you should also say that they may consider that as evidence that he did not murder Susan Berman because that body was not disposed of, and in fact he indicated to the authorities where the body was.
All right, well that's an argument, so no.
Well, in other words, what the court is doing is saying it can be considered with regard to the prosecution's arguments. I'm saying it should also be able to be considered with regard to the defense arguments. And they should understand that that is a relevant consideration with regard to the defense arguments.
The difference would be, Your Honor, it's not a prosecution argument, but the evidence that was admitted in the case demonstrated. Mr. Ray's argument is what the court indicated. It's an argument, and they can certainly make that during the closing. We would object to that modification. That's another important.
No, I don't think that it was admitted for that purpose to prove that Susan Berman wasn't dismembered, therefore Mr. Durst is innocent. That's not what that's for.
No, I agree that's not what it was introduced. What I'm saying, that's what it proves, but I understand the court's
Okay,
position.
next.
This one would be 319, which is...
Say it again one more time.
319.
319,
I
so
did
let
write
me
that one
scroll
down.
up. Just a moment.
Did you give a page, Mr. Ray?
319.
No, but
Page 8, I think it is.
what is it? 8?
Impeachment of non-testimonial, it says, excuse me, testimonial statements may be used to impeach. What I'm concerned about there is what we have is a circumstance where prior statements are being used. And what I am saying, and I understand that there's an issue regarding impeachment, what I want to have made clear is that if during the course of the sworn testimony there are statements which are inconsistent, they can be used to impeach. And I think that that's, and so I just want to make sure that that is clear from the instruction, because the way...
Let's go back to that, and the reason why is I don't know if this ever is going to apply. This is a very unique situation, but there was a Williams case which found that you couldn't impeach that it violated confrontation to impeach an unavailable witness with a prior statement with which they'd not been confronted. And so admission of that statement for its truth violated confrontation. So it could only be admitted to show the person was not truthful at the time they're testifying. I believe that's different from our scenario here with conditional witnesses. Because this led to a lot of problems, there were a lot of it was confusing. The legislature decided to rethink it, and they allowed prior testimony used to impeach an unavailable declarant that would be admissible for the truth. So I agree with you. This is an issue that needs some attention so that the jury does consider prior statements for their truth when it's appropriate to do that.
All right,
So
thank you.
I'm going to star that. I'm going to go back. It's obviously not completed yet. I left it blank and I put...
No, I understand.
Yeah, thank you.
And, Your Honor?
Yes.
And this applies to unavailable witnesses?
Only
And
unavailable
I believe
witnesses.
the only two unavailable witnesses in this trial were Klaus Dillman and Dr. Charles Harvey.
Klaus Dillman and Charles Harvey. That's
And I
right.
don't believe there were any prior statements of theirs played during the reading of
And
it.
that's what I wanted to hear from the people. So let me confirm that, and I may delete 319. It's a problem if you do have that because it violates confrontation.
Yes.
So
I believe
okay.
those are the only two unavailable witnesses. All the other transcripts that were read and or played were by stipulation.
All right. Next, Mr. Ray.
That's the last one, Your Honor, is the flight to Galveston. And I have that as being at page 12, but
Yes.
defendant's flight, and it indicates that, excuse me, that it can be considered by them to demonstrate that he was aware of his guilt in killing Kathy. I think that's totally inappropriate.
Well,
And in
hold on a
fact-
second. I've lost it. It's 3. Why don't I see 312 in order?
It's 372.
That's why I don't see it. Okay, just a moment. Defendant's flight. All right, so the paragraph, if the evidence shows defendant fled to Galveston, that may be evidence he was aware of his guilt of the homicide of Kathy Durst. So this is a typical flight instruction. If the trial were about Kathy Durst's murder, he's accused of killing Kathy Durst, and he leaves town and hides in Galveston, changing his identity, that would seem to be evidence of flight that would tend to prove that murder.
Well, Your Honor, respectfully, I think that is pushing it to the prosecution side, because there are a whole slew of other reasons why he might have gone. For example, that he was concerned that he would not get a fair proceeding if anything came against him, that he was going away because he was afraid of what was going to be happening, not that he thought he had done anything wrong.
Well, that's your argument.
Well, but once again, what's happened is that the jury instruction is focusing on a way that it can be used by the jury that is pro-prosecution without even having any possibility of them being instructed by the court that they can consider it with regard to something that is pro-defense, and I think that that's inappropriate.
So first of all, it's permissive. It doesn't say that. It says it may show. There are places in Cal-Crim where there is more restrictive language. For example, sometimes you see the form of you may but are not required to. Sometimes there's more caution. The reason, I mean, the only reason we're hearing about it is because of that, right? That's the reason why it's admitted. So, and I mean, the flight instructions have been upheld forever. I mean, I don't know. Do you have some authority that a flight instruction violates due process here, or is unfair in certain situations? I'm happy to listen to authority. I'm not just going to wing it.
I'm dealing with this one particular issue because I'm very concerned about the way this issue goes. I mean, what you're saying is it was introduced for a particular function, so this is telling them they can consider it for that function. But if in fact the evidence they introduce proves something for the defense, they have to also be told that they can consider it with regard to that issue. And they're like all.
No, I'm not saying they can't.
I'm sorry?
I'm not saying they can't. Of course they can.
No, but you have the court telling them you can consider it for them, but not telling them that they can consider it for us. So there's no harm in saying you can also consider it for this.
So when he's accused of killing Kathy Durst, ladies and gentlemen, he ran to Galveston, which may show he was guilty of the crime, or it may show he just couldn't get a fair trial. Is that what you want me to say to
He
that?
wasn't accused. He was not accused.
He wasn't accused.
Well, he was, well, sort of, not formally, but I mean, he was being investigated. So accused is not the right word. So you're telling me, okay, hold on. Relax and look at the instructions here. Let's be logical, and I appreciate your passion. All right, you're telling me your argument is he wasn't accused. So this applies if you're accused of committing a crime, though I think there's case law on that point also. But you know, work with me here. I don't want to give an instruction that's unfair. I hear what you're saying, that this describes, I mean, the evidence is incriminating evidence. So you're saying, well, it's not fair that I'm instructing them they could consider incriminating evidence, because you could also make an argument that it's consistent with a defense theory, that I should give the defense theory. But that sort of instructions, denying that kind of instruction is always affirmed as on grounds that the court need not give an argumentative instruction for the defendant's benefit.
Well,
so why is that? Why do you think there's this imbalance?
Well,
Help me
I think that
rule
there's
in
an
your favor.
imbalance because I decided to be a defense attorney, but unfortunately that's a very personal thought.
Help me.
But I just think that we're in a situation where if we're going to be saying you can consider this for the arguments that they are making, it is not appropriate to say you can do it for the arguments the prosecution is making, but we're not even going to mention the arguments that the defense is making.
Can I respond, Your Honor?
Yeah. Oh, wait, I'll let Mr. Chesnoff chime
Your Honor,
in.
he was never accused. This
Right.
is a theory. There's no evidence that it's been presented by the people, and there is no accusation. He was never charged, and this is 20 years later, and it's now how many years later, and he's still not been charged.
Well, he did say, wait a second, he said he was leaving because he feared being prosecuted. That's like being accused. Now, he adds, and I would not get a fair trial because of all the bad things people say about me. I get that. So that's his.
I think what Mr. Ray is telling you is
Yeah.
that if you're going to present the idea that they can consider it for their theory of the case, they can also consider it for our theory of the case, which is that he's constantly being persecuted.
Yeah, and of course I'm not stopping you or stopping the jury.
I know, but
on
it
that.
has a lot more impact coming from you.
Right. Okay. So not accused. So if you want to hang your hat on that, let's look at the case law for what constitutes being accused.
Can we be heard briefly, Ron?
Sure. Throw some light, please.
Doesn't it also start off, Your Honor, by presuming a crime has been committed? I mean, we don't know. Nobody to this day can tell you that a crime was committed. They can tell you she disappeared.
No. An accusation is what triggers it, not guilt. The accusation triggers it. Okay. So yes.
Your Honor, if the defense version were true, think about every case that you've ever handled. Generally speaking, we have evidence of flight, which we have in this case,
Right.
but we don't have a defendant literally saying, I took this action because I was in flight.
Wait. Oh, right.
Right. So we have the defendant literally saying repeatedly that the reason that I went down to Texas, that I went to Galveston in the first place was, I was afraid they were about to charge me. So that's step one. So the idea of this accusation is absurd because in almost every case, and the authority when the court reviews it, very few cases do you have a defendant literally admitting to flight. You just have evidence that the argument being made, and that's what justifies the instruction. He actually repeatedly says, that's why I went. But here's the second problem that you end up having, is that the defense is now apparently, their position would be that we need to be able to tell the jury why it was an alternative reason why he ended up fleeing. However, there is no case that is out there on flight that I'm aware of, that I've ever seen, that authorizes that. And if you think about it, Your Honor, every single time this flight instruction is given, the foundational prerequisites are, number one, that there is evidence of flight sufficient enough to justify the instruction. This is not, in this case, it's not that there's evidence of flight. He absolutely was in flight, concedes he was in flight, and the only question is the reason. And if you look at, it's an instruction that we have the burden in this case, as we always do. That's why the instruction is out there. So if you think about it, if the defense was correct, then that would mean that in every case, you wouldn't really just instruct on flight. You would say, listen, there's evidence that the defendant fled in this case. And in this case, by the way, Your Honor, the reason that you're able to add that additional language is because it comes from the defendant and it's uncontroverted. In other words, there is no other issue, no other evidence in this case that the defendant fled than for any other reason other than the Kathy Durst investigation. For the defense to now say, but we want you to add, Your Honor, our theory of the case. Their theory of the case is not evidence. The evidence is what it is. So this instruction is appropriate. The defense is certainly free to make any argument they want. Mr. Durst is certainly free to testify to it, both on direct and cross-examination, as to why he fled. But the fact that he fled for that reason is uncontroversial.
I'm gonna file something. I'm not gonna decide it now. Listen, you have a controversy, I'm gonna look into it.
I'm just going to say, even if he was afraid he was going to be prosecuted, that is not evidence that he did it. That just is evidence that he was afraid that somebody was going to prosecute him. And so what they're doing is they're twisting around the
There's
presumption
nothing
of
to fear
innocence.
if you're innocent, right?
What's that?
I mean, the idea, the premise is, I mean, he says they're biased against him, but ordinarily, the idea behind a flight instruction is if you didn't do anything, you have nothing to fear, therefore there's no reason to flee. I know you have the theory that he's different because he's treated differently, but really, I mean, that's a common experience. You don't run away unless there's something to run away from.
Well, except in this unique circumstance where you have a prosecutor named Jean Pirro, who we've recounted numerous examples of her misconduct when it came to Mr. Durst. It's not in a vacuum, Your Honor.
Well, I'm not going to make a legal ruling that Jean Pirro is an overzealous prosecutor. I mean, you've got your evidence and you can argue it. I don't know. I don't know. That's for the jury to figure out. But I will look into it. That's fine. Anything else?
Those are my statements.
What about these two specials? Are these yours?
Yes.
You write these?
Yes. I'm sorry they're in that form. My printer went totally
That's
dead
fine.
last night, so I
All right, first one is even if you personally believe the defendant Durst killed Susan Berman, if you recognize it would be reasonable for someone to have a doubt that he did so, you must find Robert Durst not guilty. Well, that's no, not giving that. That's a reasonable doubt instruction. Okay, second, if you conclude there's a reason to simply doubt that Susan Berman called the dean at the medical school pretending to be Kathy Durst, you must find Robert Durst not guilty of murdering Susan Berman because Durst would have no reason or motive to do so. But we heard testimony that he confessed to Susan Berman, not regardless of the phone call, that he told that he told Susan Berman, who then related it to Nick Chavin. He told me he did it. So that makes her a witness because she heard the confession. So if I get this, it would be different. It wouldn't include all the evidence, right? So I'm not going to give it. Okay. So next, how are we doing on? Oh, so now the process on the non-controversial. You still have an opportunity to object while I tell you the ones I intend to give. 200, duties of judge and jury, giving it. 201, do not investigate, I'm giving that. 202, note-taking and reading back a testimony, giving it. Special 1, defendant in custody, I'll give that. 207, proof need not show actual date, I'll give that. Reasonable doubt, of course, I give that. 222, evidence, I'm giving that. 2, special, conditional examinations as evidence.
The only comment that we have is that
Yes.
perhaps we thought maybe that instruction should come after 226, which is the witness instruction.
Okay, 2 after 226? That's fine. (223) direct and circumstantial evidence, defined. 224, sufficiency of evidence. I don't give 225 because 224 includes 225. That's circumstantial evidence of mental state. 226, witnesses. Character for truthfulness. I've got 3 variables here. Has the witness been convicted of a felony? Has the defendant been convicted of a felony? Yes, they nod. So I would give that if the defendant testifies. He'll be the one witness who's been convicted of a felony, and that should be taken into account. What is a witness?
1 second.
Yeah,
How long ago was this conviction?
doesn't matter.
Does it?
Well, you tell me. I'll consider it if it's old.
Well, he was convicted, he pled to a felony
When?
in Louisiana,
When?
Oh, that's right, never mind.
2016.
Got it. Never mind.
At the time of his arrest.
It's not so distant that I would exclude it. Okay, what is a witness's character for truthfulness? I think I should include it. Has the witness received gifts of money or services or promises of such from one of the parties in an amount you believe may have influenced their testimony? I wrote that just because there's been testimony about extreme financial support of witnesses who are partial to Mr. Durst. I haven't heard it on the other side, but I invented that. That's not in Cal Crim comments.
No?
Any objection to my instructing a factor to consider in witness credibility? Has witness received gifts of money or services
No objection.
or promises of such from one of the parties in an amount you believe may have influenced their testimony?
Well, we object, Your Honor. There is no proof of sex. Gifts are gifts. I don't think there's enough for you to have created an instruction in this instance, Your Honor.
It makes me a little nervous to give it. I mean, it's basically, was a witness's testimony influenced by a factor such as bias or prejudice or a personal relationship with someone involved in the case? I think I won't give it, even though I wrote it. It's not necessary.
Did you say you were or were not giving witnesses character for truthfulness?
I will.
Okay.
Your Honor, says the court can...
I will if defendant testifies. If he does not testify, I won't give it because there's no other evidence of witness character for truthfulness.
You know, is the court withdrawing its instruction that it made up? We think that is a very appropriate instruction, and we request that it be given. I mean, it is a factor, and when you look at the instructions don't directly address that issue. It is certainly important. Our concern is that a jury not being instructed they can consider such evidence for that purpose is going to think they can. So I think the standard for the court refusing an instruction is that instruction, number one, contrary to the law? Number two, is that instruction already covered in other instructions? If the answer is no, that it's consistent with the law, and two, it is not covered in other instructions, then I think that the court should give an instruction. I don't think the court's saying that you don't believe that it is consistent with the law or covered.
And the other side of what you're saying is it covered by another instruction? Is it duplicative? And it may be duplicative. And Mr. Chesnoff?
No, if you're not giving it, I don't have to say anything.
Well, no, I've got enormous pride of ownership of authorship here, but I'm trying to keep my ego out of it, and I'll think about it.
Well,
Can we
well,
perhaps-
if you're going to just think about it, Your Honor, if there, we're always talking about, is there, I guess, some case that I need to read to address your thought about this instruction?
Mr. Lewin, what's the authority for that idea about instructions should be given if they are consistent with the law and not covered by other instructions.
Let me get a cite for the court. I mean, I think that I know, Your Honor, you're constantly looking at authority, and we're constantly looking at authority. Having Mr. Chesnoff say, give me the authority,
I'm opposed to it.
They have a $10 million defense team there. Look up, find the
How
case
much?
yourself.
Somebody took my money.
Well,
Okay, that's,
let me
I'll get back, I'll go back to it, thank you.
Detective, I need some help.
All right, it's not worth fighting about right now. I'll go back to it.
Thank you.
I'm leaning against it, but I might give it. All right, represented witnesses, a special instruction. Court granted permission for witnesses to be represented, paid for by Mr. Durst. That's okay with me. I'll give it. 4, attorney contact with witnesses. I already read to the jury. Would you like me to give it again? That it's okay for you to talk to witnesses? Yeah, I think I'll do it. 252, union of act and intent. I had to rewrite that. I believe the only general intent crime is personal use of a firearm. I don't think you have to intend anything in particular to personally use a firearm. On the other hand, there's an intentional aspect of the other firearms allegations, and clearly of homicide, and clearly of killing a witness. Lying in wait it has an intent to kill aspect. I expect that that's correct. You let me know if I'm wrong there.
We have one more.
Yep.
Oh, I saw it. Never mind. You have first and second degree. I thought it only said second. Sorry. No objection.
Okay. I'll triple check it because I can't. All available evidence, 300. Single witness, 301. 302, evaluating conflicting evidence, giving all of those. 303, limited purpose evidence in general. I elaborated a little bit here, explaining why I gave limited purpose instructions. This is a bright jury, they'll understand that. All good things is a very truncated version of what I said. I gave very elaborate instructions about why it was for a limited purpose. Clearly, they'll remember that. This reiterates the essence of that. Is that okay, everyone?
Wait, so 303, the third paragraph?
Yes. Second and third paragraph. Second paragraph, I've elaborated on what limited purpose means. In other words, state of mind. I think in every instance, its effect on the hearer's state of mind.
And are you including the highlighted portion on third paragraph?
Third paragraph is they're both in italics because that's a trigger for me to discuss them with you.
Oh, we submitted a proposal to that instruction in the last paragraph.
Okay, I will look. Hold on, I've got it on this computer. Mr. Miata brings to my attention that 303, the limitation in the third paragraph, pertains to. So I was talking about understanding the defendant's statements, which really I meant adoptive admission. They don't come in any other way except as adoptive admission, but you are suggesting that I need to go further? Or it may be useful to refer them to 357, but.
I think so.
Yes.
Yeah, it's our position, when you look at what we added to 357, that the additional language.
What we've added to 303.
303, excuse me, yeah. The additional language simply clarifies how they can use it and refers them back to what an adoptive admission is.
All right, I'm going to go back. This is supposed to be, the whole point of CalCrim is simplicity of language. your suggestion is a start, but I need to make it clean. I need to make it more elegant. So I will reconsider 303 and 357 to see how they work in tandem, because indeed they would be in tandem.
And the people's position is that all good things is not evidence in and of itself, except to the extent it's adopted by the defendant, and it does become evidence to the extent it's adopted by him. So that's what we were trying to incorporate by referring him back to adopted admission.
All right, and you believe his approval adopts all of it?
No, no, not.
The specific statements he made on the director's director's supplement to the DVD,
Well,
and at the Jinx also. He's interviewed about all good things.
he is, yes, and he says the film was very close, the way things actually happened on one instance. So, it's to the extent the jury believes he's adopted information from all good things, as broad as his adoption might be, that's up for the jury to determine. That's why we simply just referred them back to adoptive admissions. We thought that was the safest course.
I need to look at that. I'll go back to it.
I would answer to the court's prior question.
Thank you.
Authority.
Yeah.
The authority would be California Rules of the Court 2.1050 subsection E. Quote, and I believe this is going to apply to all jury instructions, not just the civil. It says as follows. Use of the judicial counsel instructions are strongly encouraged if the latest edition of the jury instructions approved by the judicial court contains an instruction applicable to a case, and the judge determined that the jury should be instructed on the subject. It is recommended that the judge use the judicial counsel instruction unless he or she finds that a different instruction or accurately states law can be understood by jury. Whenever the latest edition of the judicial counsel jury instruction does not contain an instruction on a subject on which the trial court determines that the jury should be instructed, or when additional instructions cannot be modified to submit the issue properly, the instruction given on that subject should be accurate, brief, understandable, impartial, and free from argument.
All right, thank you. Now, let's go to 317. Former testimony of unavailable witness. I wonder if we need to, if I ought to combine that with the special on. Is that what you suggested before? That I can combine the conditional witness instruction with that?
Yes, I think they kind of fall under the same category, whether they're unavailable or whether they're stipulated to their testimony to be treated the same.
I see.
You know, we would just add that whenever we have the word, those witnesses are not available, or their testimony was admitted by stipulation. I think it might be helpful just to add that.
Whether not available or, pardon me?
Or was admitted by stipulation.
I see. Okay, I'll keep that in mind.
Thank you, Your Honor.
318, prior statements as evidence, and that was Mr. Ray's concern that not be diluted. So, of course, I'm giving 318, and I'll consider the other with reference to his suggestion. 319, we addressed with Mr. Ray. Exercise of privilege. I had gotten an elaborate suggestion from the people about documentary filmmakers acting as journalists and so forth and so on, but essentially they're exercising privileges, whether it's Stuart Altman's privilege, attorney-client privilege, which on the record, it could have been deleted, I suppose, but for some reason it was in the transcript and he invokes it, so it's fine that he invoked it. Journalists Lisa DiPaolo, Andrew Jarecki, Mark Smerling. I don't know if there was another HTGR witness. It was sort of identified collectively as an enterprise rather than as a person. But I think this covers it. Is it all right? 320? Exercise of privilege?
Yes, Your Honor. We think that should be given.
Okay, 332, expert witnesses, standard, I'll give it. Lay witness opinion, 333, I will give it. 350, character of defendant. Jean Clark did testify to the good character of Mr. Durst. She said a good, kind person. Now, I didn't actually hear nonviolent or honest, but it is a trait of character, I suppose, the kindness, the goodness, and he was cross-examined. She was cross-examined about it. So I think the jury should understand that character evidence can raise a reasonable doubt. The person's not of the character where he would commit an offense like this. And then, of course, the cross-examination illustrates things that that witness maybe should have considered. Any objection to my giving it? Any objection?
No objection.
350. 351, cross-examination of a character witness. 355, defendant's right not to testify. This is a very strong instruction, advising the jury not to consider anything about defendant's failure to testify, but if there is a reasonable doubt, if the evidence we have fails to prove it, don't consider the defendant did not testify. This doesn't apply to defendant's statements that were introduced already, in which he described his own perspective, where the jury saw his character, saw him, got a feel for his personality, which probably was missing from all the rest of the trial. So, but I'm not giving. If defendant does not testify, I give that. If he doesn't, if he doesn't testify, if he does testify, of course, I'm not giving that.
Your Honor, on that same issue.
Yeah,
If Mr. Durst decides not to testify,
yeah.
the problem that we're going to have is we will then, there's no sense doing it now because they have repeatedly stated he's going to testify. If, in fact, that doesn't happen, we're going to be asking for a special instruction from the court because the court is now going to have to go back and say, and it's going to have to be specific, there was certain information that was provided in the defense opening regarding information, this is paraphrased right now, regarding information that Mr. Durst was going to give when he testified.
Okay, well, you write that up because there's a difference between, on the one hand, if he's simply silent now, you can say those things were not proved. All right, it's premature, but I'm telling you that I will consider your instruction, but I'm also giving a lot of thought and looking carefully into comment, what is fair comment and what is not, and a lot of that's triggered in part by the opening, possibly, but more importantly by the closing. So I'm looking at that issue.
Thank you, Your Honor.
All right, but I'm going to give adoptive admissions. Any objection?
No.
Evidence of defendant's statements. This is to consider with caution any statement showing guilt unless it was written or otherwise recorded. Obviously, that's very important to the defense to be able to have that, be able to argue that. 359 corpus delicti. Any objection? I have to give it. 361, failure to deny or explain adverse evidence. If the defendant testifies and does not sufficiently explain or deny facts with which he is confronted by Mr. Lewin, I expect to give that instruction. But it's premature. It's a standard instruction. 362, consciousness of guilt, false statements.
Your Honor,
Yes?
on 361,
Yes?
if he does not testify, you're saying you're not going to give the instruction.
If he does not testify, I won't give it. If he testifies, I expect I'll be giving that instruction.
What about based on limiting it to his testimony in Galveston, where he failed to explain adverse evidence? I think that instruction still would be given either if he does or does not testify.
I think what we need to do, Your Honor, is when that situation comes to the permutations, if somehow after all this the defendant doesn't testify, then we would go back and rewrite 361. It would seem that it's not worth crafting a very careful instruction on it now when the defense, Mr. Durst, everybody said he's testifying.
All right, I will think about whether it applies to Galveston. I think not, but I will, I'll look at it. Consciousness of guilt, false statements, it's standard, I would give it. all of these things, Mr. Ray, consciousness of guilt from false statements, consciousness of guilt from flight, consciousness of guilt from suppressing and fabricating evidence. It's a series of instructions that are standard when such incidents happen. They don't always happen in trials, but when they do, this is given and it's upheld. We have not only each of these, but I've had to add aspects. It's part of this story, it seems. But all right, false statements. Any objection?
It can be clear. The reason I had a problem was the instruction as given made a specific reference to a particular situation, particular fact.
All right, so when you are specific about a particular occasion, there is a risk of it being perceived as argument by the court. So I think it's different, and the court needs to be very careful when it's on specific incidents. We have very general language in CalCrim.
I agree.
So I think that's a fair point for my consideration. Okay. False statements is generic, and I'm here, and I'm giving it. Motive is standard. I would give it. Consciousness of guilt. I added, used an alias. It seems here there were a number of acts, if revealed, they'd be incriminating. And Mr. Durst used an alias to conceal who it was who was doing these things. I think that's like hiding evidence. It fits in this instruction. The second paragraph has to do with phone calls by, it's Susan Giordano's phone calls. And we have testimony that she did from her, acknowledging she made the calls, but more importantly, Mr. Chavin testified that he heard it loud and clear, and he felt menaced to some extent.
Object because, again, it's getting very specific with regard to the facts when that circumstance is covered by the general instruction.
It is important when there is, and I'm tracking CalCrim instructions about not assigning consciousness of guilt if some person acted independent. So somebody caring about Mr. Durst, being on his side, being aware of the circumstances without any authorization from Mr. Durst, then calls a witness that says, don't testify, don't kill our friend. So he's not responsible for that unless he knew. And here it seems a fair inference, but there isn't specific evidence about that. Now, I realize you're raising a different point. I could take Mr. Durst out of it, and you could say, if you believe evidence someone made telephone calls attempting to dissuade a witness from testifying, you may, but are not required to consider this evidence that the defendant was aware of his guilt, but only if the defendant authorized these calls. I don't think it makes any difference if I call it Durst or defendant. People, any comment?
We think the instruction should be given as you have ordered it.
Thank you.
Because the evidence is very clear, Your Honor, uncontroverted. They've heard the calls, etc. That's what Mr. Durst did.
Thank you. All right. I'll give it. 372, defendant's flight. We've talked about this already. So I'm going to just I'm going to look at it again. My intention is to give it, but I'm going to think about what Mr. Ray has said about whether the specificity regarding this evidence becomes argumentative.
Say something about that,
Yeah.
Your Honor. You actually, in this charge, say he was aware of his guilt of the homicide of Kathy Durst. There's never been any evidence about Kathy Durst being killed.
I'm sorry?
Come-
I'm sorry, there's been no evidence that Kathy Durst was killed?
No,
Well, I mean, there's circumstantial evidence that she was killed.
the homicide of Kathy Durst. That comes only from Mr. Lewin's mouth.
Well, there's no question Susan Berman was murdered, because the bullet wound in the back of the head is always going to be murder. The alleged homicide, we don't know how Kathy Durst died. Could have been we don't know. So, I mean, it could be self-defense for all I know. I mean, but it's so it's a homicide. It's a death of one by at the hands of another. So, yes.
No, just that all we know, Your Honor, is that she disappeared.
Well, no, I think that there's I think that people have presented
Nothing.
you know, confession, more than one confession, circumstantial evidence of which is inconsistent with her simply disappearing. So no, I don't think to say that there isn't evidence of killing Kathy Durst is not. That doesn't persuade me, but I am willing to hear other arguments about this.
I just don't understand what the evidence is that she was murdered.
Okay, well, you feel free to argue that to the jury. But,
No, but if we're going to have an argument about an instruction, and the court's theory is that there is evidence of a homicide.
he confessed to it.
You know, we're
According to
willing-
Nick Chavin, he confessed to it, right?
Yes.
I can credit that. A jury could credit. It doesn't matter what I could credit. This is, could a jury credit that? Yes.
You know, this might help, might satisfy the
Okay,
defense.
I'm
We're more than,
talking to you. All right, go ahead, John.
Dave, this might help. We're more than willing to have the court add the word with respect to Kathy Durst. You can call it the alleged homicide. We don't have
never
any
was
problem with
alleged.
that. If that would seem to deal with their issue. We don't think it's necessary, but we're willing to go as far as we can on an issue that we don't think any jury in the world is gonna. It's a non-issue given the state of the evidence, but if they want the word alleged, we certainly.
No, you said well, I didn't say alleged.
Your Honor, we object to the instruction. We don't think there's been evidence other than what the court just said with Nick Chavin saying that he confessed.
Okay, just that confession. Okay, now, all right, 375. We have. All right, I know the people had an issue with the phone call.
Excuse me, Your Honor.
Yeah,
I don't think Chavin ever said anything about Kathy.
he said that Susan said it to him. That Susan said to him that Bob told me he killed Susie. They would argue about it. Okay, that's what I mean. Not directly to him about that.
Thank you.
Okay. So when I say confess to him, that's not true. I misspoke. Confess to Susan Berman, who related it to Nick Chavin. That the jury could credit that evidence.
On 375, I believe Mr. Miata sent a circulated draft of some suggested changes that we.
Yeah. So the suggestion was taking out the phone call. So what's your theory on that? Why did I let in the phone call if not for this purpose?
Hold on, we're pulling up.
Yep.
Your Honor, our issue with that, we believe that that it has been covered in the paragraph before by talking about the.
Okay, I see it. Just a moment.
The beginning of the sentence before.
I see it. Just a
I mean,
moment.
to be fair, we took this out only trying to be overly fair to the defense. That's all. We certainly don't have an issue with that coming in.
What it is I saw parallels between the other crimes evidence and the consciousness of guilt instruction. So I was trying to integrate them, and this was my attempt to integrate them. But the problem with this is that and I don't have it, by the way, under, see, I don't think it really fits under consciousness of,
Your Honor, if you look at the paragraph at the bottom of page 13,
yeah.
it says, if you decide that the defendant colluded with Susan Berman to use Kathy Durst's identity by impersonating her in a telephone call to Dr.
I see.
Cooper.
That's that's duplicative. I got it. I'll take it out.
So you're taking out the first.
I'm taking out the second one.
On the top of page 14?
Yeah.
Okay, thank you. Thank you.
I missed that. You know, I was going through the consciousness of guilt, and I said, wait a minute, this comes in under consciousness of guilt. I picked it up and moved it over into the uncharged offenses.
Instructions are a nightmare. The court's earning its money
With everything. So,
Have you had
okay.
worse instructions more complicated in this case? I'm going to guess no.
Now, I'll tell you a story about instructions sometime, but not right now. I had what is now the top paragraph on page 14 is depends on a defense, and that is as the people pointed out when and we're close to being finished. I see you're looking at your watch and it's not going as fast as I'd like, but I think it's going well. I'm hearing your arguments, considering them.
I was just thinking of the court reporter.
Oh, do you want a break? Soon. Okay, so we're going to take a break soon. This part about when there was yet another objection to Morris Black evidence coming in, the people raised a point that given the theory given in the opening that Mr. Durst showed up at Susan Berman's house and he saw she was dead and couldn't get a fair trial. Same thing when he went to Galveston. So he left, but wrote a note so at least someone would bury her body. That was the idea. That's eerily similar to the situation in Galveston, where he's by some mistake he's in struggle over a gun, not suspecting that Mr. Black had a gun, and he ends up dead, and he realizes, well, he can't get a fair trial, so in that case he disposes of the body. But here, this idea of suddenly, innocently being with a dead person and feeling one is to blame. I mean, that's the old story, right? You know, fool me one time, fool me two times. It's the same story. And so, one gives the same story twice after a second homicide. Yeah, that's relevant, right? That's a significant factor in deciding whether or not that's true. And so it does seem that. But that depends on the defense. I don't know. I mean, that was a suggestion by the opening statement. We got part of that from testimony when Mr. Lewin confronted some witnesses with being aware of Mr. Durst's news story. That's all we have, really. We have only a truncated version of what actually happened there. So I guess I have to wait until there's testimony or not.
Your Honor, we have a little more than that, because by the defense stipulating that he wrote the cadaver note, he can't have written the cadaver note unless he found the body.
Okay.
So, and I would also add, Your Honor, that it's even more than what the court is saying. It is literally, the dog ate my homework twice.
Right.
Two days in a row.
Fool me once, shame on me, or shame on you, fool me. How's it go? I don't know. I don't say stuff like that. It's corny. But anyway, you know the point. Same excuse twice. All right. Testimony. Oh, here's another one. A special. Nick Chavin testifies that Mr. Durst intentionally struck a Berkeley traffic officer with his vehicle, and why that came in, not sure. But here's my idea. I mean, you stipulated this thing, so from that a jury might reason he's such a bad guy that he would just assault someone for fun, and he can't be convicted based on his character. 1101A prohibits that. So I'm looking for an 1101B purpose. You got one in mind, Mr. Lewin?
Yes, Your Honor. The purpose is what it demonstrates is it explains Mr. Durst's conduct in this way. It's not that Mr. Durst is a bad guy. It's the idea that Mr. Durst does things that are not even necessarily smart. They're not even necessary to his advantage. He basically functions as if the rules don't apply to him. So as an example, that's why it becomes important. He says to Detective Struck, hey, I was with Bill Mayer at the time. Why'd you do that? He's going to go check. And Bob Durst says, well, I wasn't used to people, questioning my veracity, etc. So what this does is explain, Your Honor, that when the jury is looking at it, and some of the jurors could be saying, hey, wait a minute, why would the defendant do X, Y, and Z? Why would he say these things? It doesn't make any sense because he's going to get disproved. Well, in the end, that's what he does. So the issue is not Mr. Durst is a bad guy because he rolled the car over the police officer's leg and therefore you should convict him because he's being a bad guy. The issue is Mr. Durst believes, and he said repeatedly, even in his testimony, the rules don't apply to me. A great quote from him is, I would sit there and I would laugh at the idea that they would have to go over papers all day because I'm me. So
All right, that's fine, but I'm not going to instruct that. That's argument. So I take it along with Nick Chavin's other testimony. First of all, he knows he's intimate enough with Mr. Durst that he can testify about this, and he offered lay opinions about Mr. Durst. I think it supports the lay opinions. It evaluates his credibility. I want to, and this is a limiting instruction. In other words, this prohibits them considering it to evaluate his character. And that's, I think I'll give it that way. Agree, Mr. Ray? Agreed? Agreed that I should limit the purpose of that traffic officer's assault. Mr. Chesnoff is tracking also.
Yes.
He agrees. I'm gonna give that. Those are the purposes. All right. If I break at 11, is that going to be okay for our reporters? Can we go 5 more or no? Am I
Oh, if you
killing
break
you?
at 11?
Yeah.
Yeah, that's okay.
Okay.
I'm sorry.
Go ahead. Speak.
Are you, I just want to know, which version were you, in reviewing 375, which version are you working on?
I'm working off of version 6.0, my 6th draft on July 30th.
Okay, so we did submit some suggested modifications, and I know the court was looking at them because you do.
I did look at it, but I didn't see the yellow highlight. Oh, here it is. It comes through here.
Maybe the court would, I know we just submitted it this morning, maybe perhaps the court wants to take time to look at it and come back with 375.
yeah, it would help, Your Honor, if you had a copy of ours.
No, I'm looking at it now.
Okay.
I'm looking at it. You know, when I looked through it on my phone,
Okay.
which I shouldn't have done.
Sometimes the highlighting doesn't show up on noticing on
Right.
the phone. You don't see it.
Right. So I didn't see all this good work you've done. We'll take a recess until 11:15.
Your Honor, possibly have, it's very hot here. I'll put my coat on.
Any objection, Mr. Balian?
Strong objection.
We're Mr. Durst's lawyers to have a chance to talk with him today, and we will have accomplished enough work. But let's go back to 375. 375, paragraph 2, the people have suggested language that I think is good, specifying Mr. Durst's acquittal in Galveston. I intend to give the people's revised version. Any objection? Next, we have, and for the record, Mr. Chesnoff is present with Mr. Durst. Mr. DeGuerin has returned. We have Mr. Lewin, Milius, Henderson, Balian, and Miata.
We're right here.
The next paragraph where there's a suggestion is the homicide against Kathy Durst as also being admitted for the limited purpose of deciding whether the defendant had a motive to kill Morris Black, a plan and scheme to kill, dismember, and dispose of him. I would change it to kill, dismember. I don't like and or, but I would rephrase that and use that idea. I think that's right.
What numbered paragraph?
It would
We're on
be, it would be or,
And
yeah, okay.
What numbered paragraph?
this is 375, 1, 2, 3, 4, 5. That is the Kathy Durst homicide would be the motive to kill Morris Black. And the plan and scheme to kill him and dispose of him. Of course, because of the evidence that Mr. Black knew who Mr. Durst was, that he was in flight. And this follows the new accusation, or whatever term you want to use, reopening of the investigation. So I do think it is relevant for that purpose. And that was in the 1101 brief. I just omitted it. I did it from memory, but that's in the brief. And I adopted that brief. The next is it's Kathy Durst. I'm missing a paragraph, aren't I?
The next one, we changed the word from conspired to colluded. Just-
The one, I agree with that, but above it, you have, if you decide defendant committed homicide against Kathy Durst. Oh, I see, that's it. That's when you've added the paragraph. I'm sorry,
Yes.
I was confused. I'm doing side-by-side comparison.
Yeah.
Colluded is better than conspired.
Your Honor,
Yes?
the last sentence in that paragraph, the one that they added, we strongly object to that. I mean, that just, I don't see any import for that whatsoever.
I'm sorry, I can't hear.
I don't see any import for that whatsoever. I think it's that part that's in yellow that was added should be removed from the 1, 2, 3, I guess it's the fourth paragraph.
Okay,
Read it out loud, Don, so the record's clear with what you're objecting to.
You may also consider that evidence for the limited purpose of deciding whether the defendant had a motive to kill Morris Black and whether the defendant had a plan or scheme to commit the killing, dismemberment, and disposal of Morris Black.
Yeah, I think we've been through this 5 or 6 times now, and you took a writ, et cetera. I know you don't like it, but I admitted it for that reason. Okay, if the Susan Berman, you deleted the paragraph about impersonation because it's duplicative. Morris Black paragraph is the same. If you decide the defendant committed the dismemberment, you have added language about state of
In other words, our position is that it's.
But just let him look at it. We kind of it's hard, we kind of restructured it.
I think you've restructured it. I have agreed to the, I looked over this. I believe I already admitted the evidence for this purpose. I expect I will get that. I have questions here. The concealed firearm in the vehicle and the escape, not escape, the flight from Wegman, attempt to flee from Wegmans. That language is better than what I had.
There were 5 of us, Your Honor, so we had a little bit of an advantage.
We object to all of that. It seems totally proper.
Okay, you object to all 375 in total. It describes the reasons. It's actually to protect the defendant because it prevents the use for other purposes. I know that it protects the defendant, but it also it does highlight why this evidence is being considered and the legitimate purpose. You object to that. I understand that. what I don't understand here is a suggestion, if you decide the defendant plotted to kill Douglas Durst, you may, but are not required to consider that evidence for the limited purpose of deciding the defendant's state of mind. When he wrote the note referenced in People's Exhibit 167, Meade 5-star notebook, as it pertains to his involvement in Kathy Durst's disappearance. Okay, that's obscure. Let's tell me what you mean by that. The note what is the note? Remind me what that note says. You're doing to me. You're doing not you are. Is that the one about
What Doug Durst is doing to me puts me in the same place as what Kathy Durst.
But it says BM, not Doug Durst, but BM.
Yes, yes.
DD. No, this one says DD.
So
What DD is doing.
Yes.
we were trying to be very specific, which I think thought would be helpful to the defense, but basically the only reason to consider the evidence of his plan to, his intent to kill Douglas Durst is in interpreting that document and evaluating his intent towards Kathy Durst. That's what we were trying to accomplish.
And this ties into, just so it's clear, Your Honor, it ties into, it's kind of a three-parter. They find the information in the car. The car equates his mental state of how he is feeling currently about Douglas Durst to how he felt about Kathy. He then goes in jail and makes the calls where he is threatening or talking about how he was planning to kill Douglas Durst. So,
In other words, he can't consider the intent to kill Douglas Durst as a modus operandi to kill Morris or anything like that. We were trying to limit it to just Kathy and his intent with respect to Kathy.
right, but unless you have both and the jury is told, you can consider what's in the car, which then gets you to the phone calls, and now you have, he's equating how he's feeling about Douglas Durst, how he felt about Kathy, and he's saying that he had plotted to kill Douglas Durst, so the reasonable inference is that that's what he did to Kathy.
All right, I'm not gonna say that because it's convoluted, it's confusing. Feel free to explain that in different words to the jury. I think you'll lose them if you explain it that way, but there's a way to do it.
Okay.
I hear what you're saying, but I would limit it to
Deciding the defendant's intent. Whether he killed Kathy or something.
I'm going to look at this again. I'm going to put this on hold. I think it's correct. It is relevant for that purpose, but I just need to rewrite it. Something along what you're lines of what you're saying.
We would just add, Your Honor, that the problem if the court doesn't give a similar instruction.
No, I'm giving a similar instruction. I'll
So
do
our
it.
wording.
Okay.
I want to change the wording. All right. We'll revisit this. There's just a lot of controversy here, so I'll get back to it. So back to the list. 500 homicide general principles. I'll give 520. First or second degree murder, I'll give. 521, first degree murder, I will give. 548, murder, alternative theories. So I see you're going on exclusively on lying in wait, not arguing premeditation as a different theory.
Oh. No,
You see what I'm saying?
Yeah, yeah.
Alternative theories, lying in wait, or that whether or not he was lying in wait.
Actually, you thought a step ahead of us. We were thinking more on, we thought you were meaning we were going on felony murder or something. We weren't thinking of lying in wait versus willful deliberate premeditation.
And also witness killing.
But it is true that it would be first degree based on lying in wait and willful deliberate.
Well, witness killing isn't a theory of murder.
No.
Witness killing is a special. Lying in wait is both a theory of murder and a special.
Right.
So, I guess it confused you, so I don't want to confuse the jury.
Your Honor, you were right, we were wrong.
I guess-
548 should be there. You're right.
Okay.
Yeah.
The language is specific to felony murder. That's why.
Okay. 641 verdict forms. I'll give 700 special, and there's a choice, but this is how I'm going to give the verdict forms as described. 700 special circ introduction, standard. 704 circumstantial evidence for special circumstances is standard. I'll give it. 706 do not consider punishment. 725 murder of a witness. I put this is a unique witness murder case. I think it requires the correct legal the commentary language,
No
because, I mean, it addresses all
Yes.
the kind of heads off mistaken notions of what
We agree
this
with
killing
that.
is. 728, lying in wait, standard. Personal use, 3146. Personal use, intentional discharge, causing injury or death. This is the one that combines those two allegations
I know.
in one instruction. 3260, duty of jury verdict form for enhancement.
Can we stop on, can we pause for a second, Your Honor?
Yes.
So on the personally used firearm and personally used firearm intentionally discharging,
Yes.
Mr. Miata pointed out earlier when we were talking about, let me look for it, the general versus specific
Yes.
intent,
Yes.
252.
Yes.
Mr. Miata's pulled up something on Westlaw where he believes that the intentional discharge causing death based on the use notes would be general intent, but do you want to speak to that, Mr. Miata? You're more familiar than I am.
Yeah, so there's a case, People versus Offley, O-F-F-L-E-Y, that specifically talks about that enhancement. In the end, it says it is a general intent enhancement does not require the prosecution to prove that the defendant harbored a particular mental state as to the victim's injury or death. So I think, so the both firearm allegations are general intent.
So, but the people must prove not only did he discharge a firearm, but he intended to discharge the firearm. So I suppose that could be general intent. It's intent to do the act, as
Correct.
opposed to intent to
cause injury or
achieve
death.
some purpose.
Correct.
So it's general intent. Okay. I don't think you quarrel with that, do you, Mr. Ray? 3550 pre-deliberation instructions, 355-57 alternates. All right, the rest of them will go back. Exhibit.
There are a couple of issues that relate to the instruction.
Before you do that. We weren't sure, we were trying to go back and think. There's the instruction on the judge's comment on the evidence in case there were comments. I don't think there were, but there, in case there was anything that could be interpreted as comments, is the court feel comfortable giving that instruction, that they should disregard any comments on the evidence?
3530.
I'll give it. You know, I just love those films of the British courts where the lawyers give their arguments and then the judge, he explains how he sees it. I love that.
We'd certainly be willing.
Nah, I'm not going to do that. I can't do that. Just asking for trouble. I'll let you do it. I will give that. Thank you. Judge, no comment on the evidence. I'll do that.
Your Honor, with respect to, I think it's best to bring it up today. With respect to Mr. Durst testifying, the people are very concerned. There is a possibility that it can happen. I don't think it will happen tomorrow, whatever occurs, because of Dr. Loftus, but certainly on Wednesday. And people want to make sure, I know the court is very likely to want to take a personal waiver if he decides not to testify. We're going to want to go farther than that on our end because we have a great concern. We want to make sure that Mr. Durst understands we're listening to jail calls, we're listening to things Mr. Durst says in court, and we have some real concern as to if Mr. Durst decides not to testify, that he understands what the consequences of that are. So my question is, when would the court like us to do that? It could certainly be done today so that the jury isn't wasting their time, or we can wait until after the decision. I just wanted to put that up there.
Well, as long as he's putting it up there, I'm asked that we not be required to start with Mr. Durst before Wednesday.
Right. Wednesday. At the earliest, if not Thursday. I see either Durst testifying or argument on Thursday, and I'm going to work today a little bit on some guidelines for argument. I'll also work on these instructions, and thank you for your suggestion. Yes, I would take a personal waiver. I have also been looking at my notes about what has been introduced. There have been elements of the opening that have been introduced in different ways, so we can dialogue about that later.
Okay, understood, Your Honor.
So let's as far as the exhibits, give me your list of, and I will look at it. Let's not take any more time. We've done enough. I think this is enough for today. I promised you some time to talk to the client. Let's just so we adjourn for the day, and we'll pick up tomorrow at.
Maybe we remain with the to finish what we're doing here with the exhibits, Your Honor.
You may finish it and submit it to me, and then we'll formalize it when we go back on the record.
Tomorrow, at what time, Your Honor?
Tomorrow we're 9 o'clock.
Are we going on the record later today, or we're doing, or no?
I'll find a space
Oh,
to
okay.
do it. I think once it's all laid out, it can be done very quickly.
Understood. Thank
Because
you.
we already had an argument about
We
it.
have.
So, okay.
Thank you, Your Honor.
With that, anything else?
No, thank you.
Department 1 is adjourned.